Thank you very much. Good morning and welcome to the Supreme Court. We have two matters on today's calendar: Raspberry Junction versus Southeastern Connecticut Water Authority and Judicial Branch versus Gilbert. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel, are you ready to move forward in Raspberry Junction?
Yes, Your Honor, I am. I would like to reserve 10 minutes of my time for rebuttal.
Thank you very much. Senior Associate Justice McDonald is our timekeeper. He will hold up signs at 5 minutes, 3 minutes, and time up. How we're doing this virtually is if you see a justice raise their hand, or if you see the little virtual hand being raised at the bottom of your screen, I think it's at the bottom of your screen, please pause your argument so I can call on the justice. The justice will ask the question, then you may continue. Whenever you're ready, you may proceed.
Good morning, honorable justices. May it please the court. This appeal arises out of a one-count complaint filed by the plaintiff LLC. The plaintiff operates a small hotel and bistro in North Stonington, Connecticut. The Defendant Water Authority has been granted the exclusive right to sell water in that town, and in fact does sell water to the plaintiff's hotel. The hotel is seeking compensatory damages for significant economic losses suffered after the defendant's pumping station exploded in the summer of 2015. The explosion caused a complete termination of potable water service to the hotel for several days. And we are claiming that the harm was negligently inflicted. The defendant is a municipal corporation. The defendant was created by enabling legislation of the Connecticut State Legislature in 1967. The defendant is not a nonprofit. The defendant is engaged in the proprietary function of selling water. There is a contract between the parties, and the contract was unilaterally dictated by the defendant. The terms of the contract are rules that the defendant promulgates and installs on their website. According to the website of the Water Authority, a contract between buyer and seller exists upon the commencement of the water services. The contract at issue here is an adhesion contract. There was and never has been any negotiation as to the terms, and clearly no discussion or negotiation involving risk of loss issues. The defendant, in its answer to our complaint, admitted that they are the sole controller, operator, and maintainer of the water pump station that exploded. The defendant denied negligence.
Counsel, under the plaintiff's theory, would everyone in the district that's being supplied water, if there were allegedly negligent acts, would they be able to recover economic damages?
Your Honor, under my theory, a tortfeasor may owe certain clearly foreseeable parties a duty of care for interrupting its commerce. So I would argue no, that not every recipient of water in this district would be eligible to recover economic losses. Our theory is that, and hopefully this court will see that this defendant does have a duty of care to particularly foreseeable defendants with whom it has a particularly special relationship.
What's the special relationship?
I'm referring to the case law from sister jurisdictions, several jurisdictions, Maryland, Pennsylvania, West Virginia. They have recognized a duty to particular defendants with whom there at least is contractual privity or some equivalent of contractual privity. Also, where there's a dependent relationship, where there's a fiduciary style relationship, where there's a no arm's length contract between the parties. When these circumstances are present, sister jurisdictions find, when they're analyzing the public policy, of course, public policy seeks a limitation on these types of suits, but there is a coherent limiting principle that is being developed in other jurisdictions where the special relationship is recognized, and there has to be a close nexus between the parties, between the tortfeasor and the victim. There has to be contractual privity, an imbalance of power, a vulnerability, a dependence, or no arm's length contract.
You're on mute, Justice.
Would there be a contractual privity with every commercial party in the district?
Yes, there would be a contractual privity, but there also need, under this case law, there has to be two prongs. There has to be the special relationship and particular foreseeability of damages. The damages have to be particularly foreseeable.
Well, so it wouldn't be particularly foreseeable if you're operating commercial enterprise and there was an interruption.
Well,
all the damages springing out of that seems to be foreseeable.
Well, actually, the trial court in this case analyzed that issue properly. This is a hotel, its operations, the obvious need from the obvious need of a hotel is much different than a bank. For instance, in North Stonington, there's Chelsea Groton Bank. If there was an interruption in water service, there would be no interruption in their commercial enterprise. In the law, there's a law firm there, Attorney Steve Rex in North Stonington. He can manage very well without water for several days. There's a convenience store, but our client has, and the just trial court here in this case recognized that their operations, clearly the defendant water authority could foresee what would happen. And again, Your Honor, we are not, our complaint is not for a regular disruption. The trial court analyzed this, and it's reasonable to expect disruptions in service. There's maintenance, there's routine maintenance, but there's no expectation of negligence. And our claim that we're trying to litigate is that there's negligence here.
Okay, thank you. I see there's other justices in the queue want to ask questions, so I'm going to pass it over to them. Justice McDonald?
Thank you, Chief. Counsel, is this, I'm just trying to figure out how many jurisdictions have adopted the rule that you are advocating for?
Well, I haven't counted them all, but in my brief, I've cited 6 or 7 jurisdictions where they are not happy with a categorical bar in negligence for economic losses. It's not just when there's certain conditions, and the trial court in this case really analyzed it properly. He said that the damages were particularly foreseeable. The defendant's conduct was outside of the reasonable expectations of society in general, but this is a special defendant, Your Honor. This defendant has a monopoly to deliver reliable water service. Reliable water services.
I understand that argument. I'm trying to figure out, I haven't studied it, but is your claim similar to the claims that are pending in California against PG&E for all of the wildfires where they had to declare bankruptcy?
No, we're not similar. We're not similar. There's so many gas cases where there's negligent gas leaks and gas bursts. And what the courts are finding is that the plaintiffs become a class of people who, for circumstances, are neighbors of the gas company or neighbors or in close proximity to a gas leak. They do not recognize those claims for economic losses because there's no privity, there's no special relationship between the victims and the negligent conduct. And that is the limiting principle that that is articulated by these jurisdictions who are really crafting a coherent limiting principle. And the limiting principle starts with the relationship between the victim. So in the gas burst cases and the gas leak cases, the courts are saying, no, I'm sorry, we can't have everyone in this class recover economic losses. There's no relationship that's special between the parties. In New York City, they have numerous cases of a road being blocked, and every deli or delicatessen wants to get economic loss recovery. But the courts in New York say, no, only the ones that have a special relationship. We can't extend just to geographical close people. There's no relationship.
Thank you. I have other questions, but I will defer at the moment to my colleagues.
Okay, thank you, Justice McDonald. I'm trying to look at the queue and see who put their hands up first, but it doesn't quite work that way. My best guess would be Justice Kahn, Justice Keller, Justice Doria, in that order.
Thank you, Chief. Counsel, I wanted to ask you about the argument that your opponents make that your client is in the best position to insure against this eventuality. Meaning, if you run a business, you can take out insurance for economic loss due to business interruption. And in fact, they say that your client did precisely that. Why wouldn't it make more sense to have the owners of different businesses take out the insurance that they're going to need? Because in point of fact, the argument is that your client is in the best position to know how much coverage to get, what kind of loss would be derived from whether it's a water interruption or utility interruption. How do you respond to that argument?
Your Honor, we do have insurance for the reasonable expectation of a normal disruption. We have insurance for reasonable expectation of a hurricane or an act of God, but we can't be expected to insure for negligence, and that is the difference in this case. It's a negligent act, and the out of service time was extensive. There was not potable water for several days, and we can't be expected to insure. In fact, Your Honor, in the first,
just a point of clarification. Do you mean you can't get insurance, or you shouldn't be expected to get insurance? Do you understand the difference? Are you saying you wouldn't be able to get insurance for water interruption, or you shouldn't be expected to get insurance for that?
We shouldn't be expected to insure for a negligent act of this particular defendant who should have a duty of care to ensure reliable water service to its commercial customers. There's no incentive for, and in fact, this court in the first decision on this matter said that the risk of liability for water failure is reasonably calculable and not limitless. This is the second time this defendant has come to this court to ask for immunity. And this court found in the April 2019 decision that it is the defendant that needs to insure, and the defendant needs to have an extra duty of care to ensure continuous uninterrupted water service. This defendant has no other incentive other than this type of exposure. They need more incentive, not less.
And I understand your argument on that, your position on that. My question is perhaps a little too simple. Are you saying that you could not get insurance for this? You're not saying that you couldn't get insurance, correct? You could get insurance for this. You shouldn't be expected to. Is that what I'm hearing you say? I just want clarification. You're not saying if you went to get insurance for this type of economic loss, you wouldn't be able to get it.
We can get it. We have got it for reasonably expected disruptions, but not for this egregious negligence. We should not be expected to bear the cost of negligence.
So the answer to my question is you could get it, you just shouldn't be expected to get it. Is that the
Yes.
answer? Okay,
Yes, Your Honor.
Thank you for your time. I'm going to yield to my colleagues.
Justice Keller.
Thank you, Chief Justice. Attorney Mendoza, what's the special relationship here? There's no special contract. You kind of argue two different ways. You say this wasn't a contract at all. It was just rules promulgated by the water company. And then you try to say there's a special relationship. Why is your relationship with this water company any more special than their relationship with, I'm assuming, the hundreds of restaurants and there were 5 other hotels in their water district, and don't they cover like 23 towns total? Now, not all those towns lost water, but they do cover 23 towns, correct?
Yes.
So what's the special relationship between, why is it any more special than their relationship with anybody else who needs water?
I would argue that that under these cases in the sister jurisdictions, they recognize that commercial defendants with particularly foreseeable damages, that's the limiting principle. It has to be the defendants with particularly foreseeable damages and contractual privilege.
I have a question on that foreseeability issue. The water other than drinkable water was back on that very night, correct? The same night.
Other than drinkable water,
They
yes.
provided water to all their customers who had lost water. They actually provided you with drinkable water, correct?
No, we had 164 people in the hotel plus. So we did not have drinkable water for 164
No, but
people.
they were making it available to you. Wasn't the water company making potable water available?
Not in bottles, but we can't take the
real
risk.
reason you were shut down is because for some reason your sprinklers wouldn't operate properly. How foreseeable is that to the water company? Even though you had water, you had non-drinkable water, but your sprinklers were a problem, and that's the fire marshal who closed you. So how foreseeable was that?
The trial court found that it was, that we had 164 people that we have to protect 24/7 with water. We can't have a risk of somebody using non-potable water to brush their teeth. There's too much risk involved in this particular industry with 164 plus guests exposed to non-potable water. It was too much risk, and the guests had to leave. And the trial court found it was particularly foreseeable in a hotel context. For a hotel, this is particularly foreseeable to the defendant.
All right, thank you.
Justice Story.
Yeah, it's along the same lines of the insurance. I guess, am I oversimplifying it to say that your client is sort of expecting all the other customers, commercial or otherwise, that can't fit themselves within your definition of special relationship to foot the bill for your disruption? Everybody's disrupted in some fashion, maybe not to the tune of what you are, but either through higher rates or the need for the company to get insurance. Everybody's going to underwrite your losses.
But yes, Your Honor, because our claim is not a normal disruption. We're not suing for a normal disruption. We're suing for negligence.
Why should all the other customers pay for your? Why should somebody that gets the water that's just a resident of the district have to pay for your risk of something beyond a normal disruption?
This issue was decided by this court in the first opinion. This is the second time we've been here. The first opinion said that it is the defendant that needs to prepare for its negligence. First of all, it needs extra incentive to not be negligent. And second of all, it has a reasonable, calculable way to set its rates. And why shouldn't they set their rates?
But that case was about they couldn't promulgate something that says that they can't create their own immunity. without the legislature blessing it or something like that.
And one of their defenses was you're going to have our rates skyrocket if you expose us to liability. Our rates will skyrocket. And the court said maybe they should skyrocket. If you're going to be negligent, then you're going to have to set rates equivalent to your expectation of negligence. Either that or this. There needs to be incentives.
This will be my last question. Do you pay a different rate than other commercial entities?
Yes. This hotel pays an extremely high rate for the water, extremely high.
It's calculated differently? I mean,
yes, it's calculated based upon the usage because we use so much water. So there's a higher rate.
All right. Thank you.
You have 1 minute on your main time, Council.
Yes, Your Honor, I just wanted to reinforce the public policy conclusions of other jurisdictions, that there is a class of plaintiff where duty must extend. And from a public policy point of view, we really disagree with the trial court where they say that this defendant doesn't need incentive for increasing their care in the delivery of water. We disagree. This defendant does need incentive. They're a monopoly. There's no competition. There's no regulation with this defendant. They're completely unregulated. We have no other recourse to bring our complaint other than the court. Where this defendant is negligently delivering an unreliable water supply, public policy of this state should encourage more care, not less, in this area. They make their own rules, they're unregulated, they're unaccountable. This is an area of public policy where I'm hoping that the court will find a need to bring this defendant accountable.
Thank you very much, everyone. You have your remaining time. Is counsel for the appellee ready?
I'm ready, Your Honors.
Thank you, counsel. Please identify yourself for the record.
Stephanie Berry for the defendant appellee, Southeastern Connecticut Water Authority, which you may also hear me refer to as SQUA. And if I do, I apologize. I'm just so used to saying it that way. Thank you, Your Honors. May it please the court. The question before this court is whether the defendant owed a duty to this plaintiff for purely economic harm, namely lost business revenue allegedly caused by the defendant's negligence. And it's our position that the plaintiff's claims here are barred by the economic loss doctrine. We would argue that it's oh, yes, Your Honor.
Justice Keller.
Now, there's a board that oversees the operation of this water company, correct?
Yes, there is a 7-member board. There's also the representative advisory board, which
yeah, and you said that,
is made up of 2
elected officials from all the towns that get their water are on these bodies.
Yes.
Okay, so what kind of elected officials?
Sure. The representative advisory board is made up of 2 residents of each of the 21 towns that SWA services.
Do they have
and
to
then
be
there's
elected officials?
Well, I don't think that they're elected by the towns as a whole, but they're appointed by the 7-member board.
Officials. Okay.
Yes, yes.
All right.
Now,
last year when we had the terrible storm where the electric companies were criticized for not restoring power fast enough. Obviously, the big electric companies do have some statutory immunity from these kinds of suits. But in terms of public policy, if it were really egregious and extensive, the legislature created your client. They could also uncreate it, or they could do what they did to the utility companies in the last legislative session and actually pass legislation that ordered them to make reparation to some of their clients because it was a very unusual and unique situation. That's possible here too, isn't it?
Yes, Your Honor, and that makes a good point, because the plaintiff argues that we're a monopoly, but I mean, this is a legislatively created authority. We couldn't just close up shop because it's financially unfeasible to continue providing water. They're required by statute to exist, and while it's not subject to the regulations of PURA, there is the 7-member board. There is the what is essentially the 42-member representative advisory board. It is audited every year by an outside CPA, and you know, if the employees of the authority were to continually be acting negligent, the boards would do something about it. They would fire them. They would get new staff. So to say that there's no accountability here, and by the way, the board also has to be made up of people who live in the district, so they do have an incentive to keep the water running.
Did you offer this hotel potable water?
I'm sorry.
Did you offer the hotel
Potable water.
in the form of what, bottles of water?
Correct.
And did they accept them?
Correct. I know not by definitive proof, but I believe they did not, that they got their own bottled water.
And did they in fact collect insurance from their carrier?
They did, Your Honor. There was a $25,000 policy that covered this loss. And that also goes to another point, that SQA would not be in the best position to allocate the risks for each and every one of its customers. I actually disagree with Judge Kalmar, the trial court's decision with regard to foreseeability. Yes, anything is foreseeable, but I think that for SQA to be able to foresee the particular losses that could come about by each one of its customers is going too far. This plaintiff did allocate the risks, but even they didn't allocate them high enough. So how would SQA be able to do so? I see other questions.
Thank you. Justice Keller, do you have anything?
I'm done. Thank you.
Thank you very much. The queue seems to be working the way I think it should work now. So Justice McDonald, Justice Daria, Justice Ecker.
Thank you, Chief. Counsel, what is your client's incentive in this scenario to not be negligent?
To stay operational, to provide the public with their water. The people who work for the authority and the board members live in that district.
What's your financial incentive not to be negligent? Not goodwill. What's a financial incentive? If, like any party, if you are continually negligent, even if you have insurance, there's going to be consequences. You're going to be dropped by your insurance. Your rates are going to go up. That's one financial incentive. The other would be that in order to cover these losses, if there wasn't enough insurance, they would have to raise rates, and that would cause a ripple effect across the district. Wait a minute. Hold on, counsel. That's very confusing. You're saying that there's no liability. Your rates wouldn't go up at all. Where's your incentive to not be negligent if you are going to be exempt from liability?
Oh, I misunderstood, Your Honor. I understand now. Besides goodwill, what is their financial? I mean, I'm not sure how to respond to that, Your Honor. I mean, they are a not-for-profit, so it's not eating into profits or anything like that. I mean, I think the incentive is mostly just goodwill and to continue operations.
I mean, that's sort of begs a question that I guess we don't need to get into, but I don't know if a monopoly needs much goodwill if they're the monopoly. But let me ask you a different question. It's sort of the inverse of that. Can you give me some other examples where property owners not only need to buy insurance to protect against their own negligence, but to protect against negligence that is that befalls them by others, where they have to, where the risk for both sides of negligent conduct falls on the same party? Do you understand my question?
I did until the end. I'm sorry that when you said the same party.
I probably should have shut up then. Your view is that that the plaintiff would have to buy insurance for their own negligence that they perform on their property vis-a-vis their customers or whatever, and they should additionally buy insurance to protect themselves from your negligence. Give me some other examples where it falls on them to protect against negligence on both sides of the liability equation.
I mean, I feel that it comes into play with every type of business. Even individuals, we get underinsured and uninsured motorist coverage along with our own general liability policy. Companies often get insurance for business losses that could be caused by someone else's negligence. We've seen it throughout the cases that were cited in both parties' briefs. Workers' comp insurance to other type of business loss insurance when somebody's prevented from. I'm not sure if it was actually briefed in this case, but I remember a case about a law was brought up before about a law firm that was prevented from operating because of not having power in the office, and they had insurance to cover those losses. So I feel like it's kind of limitless. It comes up in every avenue of life and business.
Were those negligence or recklessness type cases? Or just interrupted service?
I mean, I've seen it with both, acts of nature, but also negligence of, I think it was brought up about, you can have an interruption of service due to a storm. You can also have an interruption of service due to the negligence of the utility. What I'm also concerned about is a situation where if these economic losses.
Those are very different interruptions. One is an act of God. One is somebody not doing their job. I mean, if in the example that Justice Keller gave, if United Illuminating or CL&P had one truck around to respond to a natural storm, and one crew, would that be fine from your perspective if it was your client?
Well, my client is very small. It only has 7 employees. It is a micro utility. So it is very different.
The principle here will apply across the state. So I'm just trying to test the outer rim of where this logic goes.
Well, I think we look at who is in the best position to allocate the risk, and to require a micro utility like SQUA to assess what each individual customer's risks would be is unreasonable and really undoable. The plaintiff here.
This will be my final question, because I appreciate my colleagues' patience. My final question is, why is that true if your client can buy insurance and spread that risk over all of its ratepayers to be a de minimis rate impact, as opposed to having it all fall on one entity that suffers from your negligence.
But it wouldn't be just one entity, Your Honor. I mean, here there were over 200 residents and 13 businesses that were affected. So this plaintiff is claiming over 100,000 in economic losses. So what if that you times the 13 other businesses? Now you're up to 1.3 million. Not to mention all the individual residents who are going to have claims. How much is enough insurance?
Okay.
If the plaintiff,
special relationship thing, but I'll yield to my other colleagues now. Thank you, counsel.
Thank you, Your Honor.
Thank you, Justice McDonald. Justice Daria.
Thanks, Chief. The just being a little.
Up, you're muted.
Justice Daria, you're muted.
But I unmuted. Sorry. Thank you. I'm being more precise about the public policy factor, the discouraging negligence. Do you disagree then with the trial court? The trial court says the defendant can still be held civilly liable to its customers that suffer personal injuries or property damage due to its negligence. I'm gathering from your responses to Justice McDonald that you disagree with that you would say that you're not going to be liable, and that otherwise that would be your financial incentive.
No, they are still able to be sued. That your honors held that in the prior appeal. The SQA can be sued. It can sue. It can be sued. It can enter into contracts. What we're saying is the economic.
Maybe it was a broader ruling than I remember. I thought that was about you promulgating your own immunity. But I mean, are you going to claim some? If somebody has a personal injury or a property damage claim for negligence, would you claim some other governmental immunity?
Oh, absolutely not. I mean, that's what the prior appeal.
Okay.
I mean, I know it wasn't about.
You think that's enough of a financial incentive for you to?
Absolutely. I mean, there is no personal property damage, personal injury or property damage to the plaintiff here. And that's the whole point that we're saying the wholly economic losses should be barred by the economic loss doctrine.
Okay,
because
great. Thank you.
Ripple effects.
What's that?
Thank you, Justice Daria. Justice Ecker.
Well, it just so happens my questions sort of follow right on Justice Doria's, because I was wondering also about sort of the limits of the doctrine that you're advocating for. I mean, it's a little weird that to some extent the limit depends upon the fortuity of what kind of injury gets caused by the negligence, right? I mean, in other words, it's hard to think of an example maybe in your line of, in this type of work. It's easier maybe with electric utilities or something. But, if there was a surge of some kind that flooded the hotel or caused property damage and consequent economic loss, there would be liability, correct? If there was negligence, right?
There'd be exposure to liability.
Thank you. I don't want to get too many concessions out of you. But, there would be exposure to liability. So really what we're talking about here is, you could call it the fortuity of the fact that this is a disruption of service caused by negligence as opposed to an incursion, a physical incursion of some kind, right?
Right. I mean,
go ahead.
Go ahead.
Well, just to continue, and then you can answer. I mean, because I did see the Scanlon case cited by your opponent. It's in the reply brief, so I'm not going to expect you to have studied it. But it's a CLNP case, by a dairy farmer, and the claim was the voltage hurt the cows, and there was business losses. In fact, there was emotional distress damages, and our court said that's all fine, just because of the voltage, I guess the negligence associated with the voltage injuries. So you don't quarrel with that result?
No, Your Honor. I mean, that case involved, property damage to the cows, which then created lost profits, I suppose. It's derivative.
So I guess my question is
have,
really, what's the difference? I mean, we can articulate a difference. Is it a principled difference? It's sort of a 19th century physicality idea. Is there a principled distinction?
I think there is, Your Honor, because when you're talking about this type of loss, the ripple effect goes out much further than when there's an accident that causes personal injury or property damage to a given person or entity.
I guess another way of saying that, though, is just that more people get hurt because of this kind of consequence rather than another. So it's, I mean, I guess that's a distinction. I'm not sure it's a distinction that's persuasive. It may be just a policy basis. We can't afford to impose liability of this kind of nature. Maybe that's it.
Well, it's definitely going into the third prong of the public policy analysis that it would open the floodgates. Every business that's affected would be able to bring suit. Every individual who bought a case of water, every individual who said, "Oh, I need to go check into a hotel for 2 days because I don't have water," every individual who was going to host their daughter's wedding in their backyard and now has to move it to another location and pay that. These are all the foreseeability becomes so tenuous. The ability to defend the proofs involved in each individual, it would become untenable, unfathomable,
okay,
almost uninsurable.
I'll yield to my colleagues who have other questions. Thank you for your answers, counsel.
Thank you, Your Honor.
Thank you, Justice Secker. Justice Khan?
You're muted, Your Honor.
Thank you. Thank you, Chief. So I have two questions. One, all around sort of this issue of who's in the best position to insure against this. And I'm not sure, I've been struggling with an example of where there would be an interruption of service that would not be an act of God, a storm, hurricane, but also would not be negligence. So is it possible to have interruption of service because for whatever reason, the machine just breaks? Or does it ultimately always come down to negligence? I suppose the claim would be, well, if the machine broke, it's because you weren't providing appropriate maintenance.
Well, that's
the nature of the business is, I would think that sometimes things break and it's no one's fault necessarily. Are there any cases where that's the situation? It's just not an act of God, not outright negligence.
Well, first, that's exactly the scenario we have here. The pump broke. Plaintiff is alleging it's due to our negligence. If things don't go our way in this appeal and we have to litigate that, we'll find out if it was negligence or not. But yes, the contract anticipates that water will have to be turned off for general maintenance from time to time. What if that general maintenance is worse than once they go in to fix something or update something or what have you, and they figure out it's worse? How many times in construction, home construction, business construction, has that happened? Oh, this quick little fix turns out to be something much bigger and it takes longer. Then that interruption becomes more than what was anticipated. I do see things like that. I also see what I think Justice Keller brought up about the electric companies. The disruption is caused by an act of God, by an act of nature, but then they don't work fast enough. They don't have enough crews. Maybe one of their repairs goes sideways, and causes even more havoc. You could tag on negligence to an act of nature, and then it just keeps going.
And my second question, because I know my colleagues have other questions, I don't want to take up all of the time. My follow-up question is this, and I get your argument, both in your brief and now here in oral argument, that for your client to insure against all these eventualities, you can't. You don't know how many people are planning a backyard wedding just precisely at the time that water service is cut, and now they're going to have to go to a new venue, or they lose deposits on vendors, whatever the case may be, and that you can't insure against economic loss to each and every entity. It is part of the argument, I guess, that you're making is also that if your client were the one that had to insure against at least the known businesses, one, that it doesn't know exactly what their loss would be, because you're not in the business of renting hotel rooms or venues. So you don't know what their income stream is, what they're paying their employees, what the loss would be. And two, that even if you were to insure, that would mean that every resident in your service area would pay the cost of that insurance, presumably, because you'd have to divide it, or at least include it in your rates, correct?
Yes, on both counts. Yes.
And is the rate is the same for every resident? They pay based on usage, correct? But the rate is the same?
Yeah, that is true. And I don't want to pontificate too much on this, but I will admit there may be special arrangements with different entities if they have gone before the board and asked for those things. And that goes into that same argument. There are avenues here. This is an adhesion contract, but I mean, our lives are just filled with adhesion contracts.
I don't want to take up your time, but now you're confusing me a little bit. Are you saying that different entities get charged different rate? Because your opponent said, hey, we pay more. And then when asked, she said, we pay more by usage. Well, if you use more, you're going to pay more. What I'm asking is everybody charged the same rate for water, or do commercial entities get charged a premium?
Oh, I don't know. My understanding is it's all based on usage, but I do not know that, for certain.
All right. Thank you. I'm going to yield. Thank you very much, counsel.
Thank you, Justice McDonald. There's 5 minutes remaining in your time, counsel. Justice Keller.
Thank you, Chief Justice. Attorney Berry, could you elaborate on why this isn't a special relationship contract?
Sure. Well, first of all, it is an adhesion contract. It's the same contract that each of the customers, which I believe there's 2,083, something like that, connections. So that just means every single, there's over 2,000 hookups.
Would a special relationship possibly be something like, for example, the MDC in Hartford area was going to enter into a special contract with a water bottling company, and the rest of the customers kind of got up in arms. Is that the sort of special relationship that these cases that talk about special relationships contemplate? Some special contract between the utility and a business? Yes,
I would say so.
I want to say, last year or the year before, there was a bacterial invasion in a private water company's water sources in South County, Rhode Island, and it covered at least 2, possibly 3 towns. And no one in all of those towns for almost 3 weeks could drink the water. Everything had to be boiled if you were going to cook or drink. Hundreds of restaurants had to close. Beaches were closed for a few days. People had to cancel events, which is why they tell you to buy event insurance. And from my point of view, the cost could be astronomical if everyone who's inconvenienced or isn't able to run their business for a few days, then it can go on a lot longer. It took 3 weeks before the water tested clean again. And I can't imagine what people would be paying for water if this were the case, where the utility company would have to reimburse everybody who had some kind of an economic loss because of interruption.
And that is our fear here, to be able to anticipate and allocate and specify for each individual with regard to economic losses only, not damage to property or person. It would be unreasonable.
Thank you.
Thank you.
Justice McDonald?
Thank you, Chief. Counsel, would your position be different if this was a recklessness claim?
I mean, the economic loss doctrine deals with negligence, not recklessness. So I would leave it to applying only to negligence claims.
Okay. So if this were not your small utility, but this was Flint, Michigan, you would still say, even in that, if the allegation is only negligence, there would be the economic loss doctrine would still apply, even though it had massive consequences to the public at large.
And the only thing that could be proved, and the only thing that could be proved is negligence, then unfortunately, yes. I mean, it's stated in several of this court's cases and cases throughout the country that we want a remedy for every wrong, but the law does need to put limits, because we can't, the floodgates of litigation, the limits of insurance coverage, there do have to be limits put on some of this, and there is nothing preventing the plaintiff and other similarly situated affected businesses and residents from procuring their own insurance and assessing their own risks.
Thank you. You have 12 seconds left.
Okay. So it's our position that plaintiff's claims here are barred by the economic loss doctrine, and we respectfully request that the court uphold the trial court's decision in granting our motion for summary judgment. Thank you.
Thank you, counsel. Attorney Mendoza.
Thank you, Your Honor. I want to clarify, I want to use my time and clarify the coherent limiting principle that other jurisdictions have established for this type of case. And the case that really explains it well is the Aiken versus Debow case from West Virginia. That case actually involved a hotel that was in West Virginia, and a truck driver smashed into some overpass and prevented traffic from going in front of the hotel. And the West Virginia court said, we are not going to allow the hotel to sue. Actually, the hotel is looking for $9,000 in damages for lost revenue. The West Virginia court said, we are going to establish a limiting principle on people who are suing for economic loss. In this case, there was no relationship between the tortfeasor, the truck driver, and the hotel. The state said, we're going to require preliminarily a relationship between the two. So that is where the term special relationship comes. I'm not arguing that my plaintiff is special. I'm not arguing that at all. The case law says first we have to look for a relationship. We're not going to allow people who live within 5 blocks of a gas explosion to sue for economic losses. We're not going to allow for a hotel whose road was blocked off to to sue for economic losses. We're only going to allow where there is a relationship between the conduct and the tortfeasor and the victim, hence the term special relationship.
Thank you.
So I wanted to clarify that.
There is a question, Justice Khan.
Thank you, Chief. Counsel, just something you said triggered this question for me. So would a resident in this town, in this area, who was planning a backyard wedding also have that same special relationship that your client has and be able to sue if they couldn't hold the wedding because the interruption was right at the time the wedding was supposed to occur? Do they have a special relationship as well?
Under this case law that I'm citing, yes, they have a special relationship because they have contractual privity with the tortfeasor. And again, assuming negligence, I'm not assuming a storm or act of God here, I'm assuming negligence. They have the relationship because they have a contractual privity, but their damages are not particularly foreseeable. If I was the judge on that case, I would say you failed the test, the limiting principle, because the backyard wedding is not something that the water company it should be expected to foresee. Again,
but this day and age, in light of COVID, couldn't you expect that most functions would occur outdoors, and so people are more likely to have weddings and other events outdoors? I mean, isn't that? I mean, what you're basically saying is that everyone has a special relationship who buys water from the water authority.
I'm saying that yes, they have, where a special relationship is defined in the case law, there is contractual privity. Then you have to go to the next prong, and I would argue that the backyard wedding and party is not particularly foreseeable in terms of damages that we would expect the water company to reasonably anticipate. However, as the trial court here said, the particular foreseeability of the type of harm that this particular defendant was going to have is unquestionable. The trial court was very clear about that in their opinion. And so to your example, I would say, and also the example that I cited, the zero relationship between the tortfeasor and the hotel. In those cases, we're not going to allow the plaintiff to recover their economic harm. So what I'm arguing today is that I'm hoping that the public policy of the state of Connecticut will craft a limiting principle. I'm not asking for a ripple effect. I'm not asking for a floodgate here. What we're asking for is to recognize that there's certain plaintiffs and certain tortfeasors where there needs to be a remedy for commercial harm. This particular defendant has no incentive to increase their standard of care. They really don't. There's no competition, and counsel referred to the board that oversees the SQA. Well, we're not going to get our $125,000 from that board. Our client is out of pocket $125,000, and we're claiming it was negligently inflicted harm. And we feel that this case and the facts fit into the two-pronged test that is required to limit recovery from economic losses. You first have to have some relationship with the tortfeasor, and second, your damages and your claim has to be particularly foreseeable. If you have both of those elements, we're arguing that the interruption of commerce needs to be remedied. There can't be no remedy for this particular plaintiff. And we have no remedy. The court is our only hope to recover. And with respect to there's been a lot of talk about floodgates. Again, I reiterate, the bank is not going to have particularly foreseeable damages. The law firm is not. The gas station is not. It will be limited to those with particularly foreseeable harm. With respect to my client, they cannot operate without potable water. There's too much risk to their clients. And their clients should not be forced to be in a hotel that doesn't have the safest possible water. And I would hope that the public policy of Connecticut is, oh, I'm sorry, I'm not responding to the questions, I'm sorry. If there's a question.
Yep, there are questions. Have you finished answering Justice Khan's question?
Yes.
Thank you very much. Justice Hacker.
Counsel, usually in tort law, special relationship has a particular meaning of a fiduciary type relationship, a duty that imposes an affirmative, relationship that imposes an affirmative duty of care, common carriers, children, things like that. You're not talking about that kind of special relationship, are you?
No, we're talking about the first one is contractual privity. So let me ask. Okay, let me ask you about that. You know, under the rule of, I remember from law school the great case of Hadley against Baxendale, right, which set the limits of contractual damages. It's the broken crankshaft case. I mean, you don't even need tort liability other than the unusual features of this contract, which, you know, has these no liability terms. But you would say under any normal contract for services or supplies, this kind of damage is not consequential damage. It's foreseeable and therefore collectible under the contract for breach of contract. Well, this particular contract doesn't have a proviso. In fact, they're claiming immunity under their rules.
So why do you need negligence law? Why don't you just sue under the contract and say, hey, you breached the contract. These are foreseeable damages. Foreseeable damages are collectible in contract law. And why do you need negligence law at all?
Well, you don't have a term. There's no, the terms are unilaterally dictated of the contract. The contract that was dictated by the defendant didn't provide any remedy for breach of contract. There's no remedy provided. It's not an arm's length contract. And in fact, under the case of Enslin versus Coca-Cola in Maryland, that was one of the, there's a list of possible parameters of a special relationship. And one of them is if there's no arm's length contract between, if there's a dependence, we depend on this defendant, we depend on them. We need this court to recognize that a water company with a monopoly and no other accountability or regulation by PURA needs to have a standard of care to deliver uninterrupted water supply. Again, we're not talking about a storm or an act of God. We're claiming that we had negligently inflicted harm. We don't have a contract remedy in this contract, but they made their own rules. They made their own contract.
Okay, thank you. Thank you for that.
Thank you.
Thank you, counsel. You can wrap up if you'd like, if you have anything very short.
I'm asking this court to continue with their wise decision not to apply a categorical bar under the economic loss doctrine. They've never found it necessary before, and I'm asking this court to adopt the coherent limiting principles that other jurisdictions have. This is a great state, and I don't see the state of Connecticut permitting negligence without recovery. Thank you.
Thank you, counsel. Thank you both, counsel, for attending this matter. We've been able to go forward with our work because of the virtual platform, and we thank you for your patience and the technological difficulties we have sometimes with it. With that, we will be in recess until the next matter.